There's a big gaping hole in the patent law when it comes to claim over breadth. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. This is the first of a two-part video series on how the law handles claims that are overly broad. If you like this content, please like, follow, and share. I would appreciate it. So claim over breadth, the problem I'm talking about is not claims that are overly broad relative to the prior art. The law is well developed there. If a claim is too broad relative to the prior art, it can be invalidated for lack of novelty or for obviousness. What I am talking about is claims that are very broad relative to the particular embodiments the inventor developed and disclosed in the patent application, and which end up reading on technologies that were well beyond the conception of the inventor, and in which in some cases required technological leaps that took place after the inventor's patent application was filed. Now, here's the thing. Under the law, claims are not limited in scope to the preferred embodiment in a patent or the specific embodiments. That's black letter patent law, that claims are not limited in scope to the embodiments. Claims are supposed to be given a scope based on their plain and ordinary meaning as understood by skilled artisans. So then the question is, what do you do when the claims end up being so broad they sweep in things that require a lot of technological leaps or that were well beyond anything that was possibly within the conception of the inventor? I'll give you an example from a case I was involved in 10 years ago. Somebody developed a patent and it described a dummy computer terminal. It basically had a graphics card, a screen, a keyboard, but no real CPU or computing guts. And then it wirelessly communicated with a PC at some distance, not a great distance. And so they drafted claims to this system. And those claims ended up reading on smartphone technology that required huge leaps in processor capability after this patent application was filed, and which required things that were not remotely or conceivably disclosed in this patent. And the question is, how do you handle that situation given that claims are entitled to a scope that goes beyond the embodiments in the patent? In other words, where is the line? How broad is too broad? And what does the law do to constrain claims when they end up reading on these things that are so far beyond what the inventor actually developed? We'll talk about how the law handles that in the next video, but that's the problem we're talking about. So please join us for the next video. I hope that helps to keep you out of trouble, and I'll see you here soon.